One of the things we need to consider about the connection between ethics and law is the justifications that we require to use the coercive effect of making something a legal rule. So it's something more than the type of argument we might have about the best answer to a dilemma. It's not just a question of the right thing to do, but a question of using the force of law to make sure that people who don't agree about what the right thing to do is nevertheless have to accept the rules that society has enshrined in their legal system. So if you like, you might have a debate with a family about whether or not it's the right thing to carry on treatment, or why it is not appropriate to shorten someone's life. And you might have that argument about what's in the interest of their loved one. And if you lose that argument and they want something that is not accepted under the law, so they would like to have their loved one's life terminated now, or maybe they think that you should carry on treating even though the clinicians think it's not in the best interests of the patient, ultimately the law is going to say that they can't have their own way, even if they are clear that it is the right thing to do. So we need the sort of justification that explains why it is that even when you lose the ethical argument, the law can still override the failure to persuade people. So that requires us to, if you like, upgrade the type of argument that we would have about the right and wrongness into the type of argument that says that we can override disagreements, we can override a plurality of views. And that's what we need to consider at this stage. And I want to talk to you about four sort of approaches to trying to resolve that question. The question why I'm right and you're wrong, and might is on my side, even though I haven't persuaded you that right is on my side. So one way into that is to try and argue that there's a difference between things we decide for ourselves, the private parts of our lives, and those things that have a public dimension. And this is sort of the logic of the European Court of Human Rights in the Pretty case, where they held that you did have a right to respect for your private and family life, which meant that your decisions should be taken seriously. But nevertheless, there are some public interests that have to be balanced against that. Most importantly, the need to protect other people who might be vulnerable if they were in a similar position to you. And therefore, you can't have what you want, because we need to protect the whole range of people in society, and it isn't just a matter of what's right and wrong for you. And in the recent Conway decision, it's been suggested that we might also think about that in terms of society's claim to respect the sanctity of life in a particularly strong way. And it may also be that society has a legitimate interest in the importance of trust between patients and their doctors that justifies you limiting the freedom of some people to promote a wider public value. So that's a debate about the extent to which decisions about end-of-life care and euthanasia are really private decisions, or the extent to which they're public. And another way in which you might think about them as being public is the engagement of health professionals in assisting people to die. And so some argue that we could only ever introduce physician-assisted suicide along with some form of conscience clause which would enable clinicians to opt out of what would otherwise be a legally permissible act. If you like, they can say that is the law of the land, that this is permissible, but I'm not prepared to live by those rules. I have a sense of opting out of the obedience to the normal expectations of the law. So the public-private distinction is one way of thinking about that, and you might want to test out your thinking on how far you think a euthanasia decision is a private decision and how much it has in terms of public dimensions. A second way of thinking about this, which is linked with that analysis, might be a question of rights arguments. And here we might want to argue that there are certain things that a general public debate is not entitled to compromise. So we hold on to the idea of a right to life, and that means that people are entitled to protection from being lynched, and it doesn't matter how much the population around them thinks that someone deserves to die. That remains an unacceptable position, and it's the job of law to, if you like, protect individuals against democratic decision-making processes. Well, so we need then to work out what exactly are the rights that are at stake, and we might look at that in a number of different ways, but one of the key debates is about whether or not the right to die merely protects people against being killed. So it's a negative right to protect a particular type of permanent infringement of my rights. I will never be able to decide anything again if I'm killed off. Or does it entail a positive right to choose the manner of my dying? Now, if this is a human rights question, you would expect that to be a debate that can be resolved globally and resolved in a way that would hold good in lots of different health systems. But if it's just a citizens' right question, then you would expect that to be debated within particular cultures, and you might accept the fact that different cultures have different views. Now, in human rights law in Europe, we have an idea called the margin of appreciation. We recognise that these are contested areas, and we wouldn't regard it as something that's fixed in European human rights law until there is something approaching a consensus across the nation states of Europe. And we can't really say that's the case in relation to end-of-life care, where we can see clearly that there are very different views about acceptance of the right to die. So if it's not a human rights issue resolved at a transnational level, then it might be that it's appropriate for democratic decision making. And we know that different countries use democratic decision making in order to resolve issues of bioethics, including end-of-life care. So the Oregon framework for physician-assisted dying, which is a model that is attractive to many campaigners in the UK and has lain behind some of the proposals put before the UK Parliament. That model was actually approved by a plebiscite, by a referendum. So it was passed because a majority of the citizens of Oregon voted for, or the majority of people who voted for it in a referendum. That's a very different type or way of resolving bioethical debates than some form of commission, such as we had in the UK in the Falconer Commission, or a parliamentary debate by elected representatives who are not bound simply to do what their constituents say or want, but they are bound to address and resolve the arguments. But if we go down the democratic route, we would be a little bit worried about the so-called tyranny of the majority. Do we recognise the validity of a plurality of views, and are we prepared to allow the majority to impose their solution on all members of society? What are their obligations to allow for a degree of plurality? And many would argue that the idea of human rights is designed partly as a constraint on majority decision making. But it could well be that your view is that the proper resolution to the debate about why a patient can't have what she wants is a debate based on, well, this is a decision that's been reached by due democratic processes and we participated in that processes. We may not like the outcome, but because we've had a fair say in that process, we're somehow bound to accept the outcome. We can campaign for it to change, but while it's in place, we're bound to accept it. So the first sort of approach to this was a question of trying to balance what's public and private. A second approach was looking for agreed conventions on which things are so important and fundamental that they count as human rights and therefore should be held onto even if they make life difficult or uncomfortable. A third approach based on democracy is more based around the fairness of the process. Did everybody have a fair say? Are all the arguments articulated? And if the process is sound, then we should regard ourselves as bound by the outcome, even if we have lost the arguments, we've had a fair say. And the fourth approach that we might want to think about is an approach that in the history of England and Wales has been debated around issues like the legalisation of homosexual practices, the question of the accessibility of pornography, and it's a debate that's been held in terms of the legitimacy of enforcing one set of moral views on all the members of a pluralist society. So what is the type of argument that might justify you taking a view about the legitimacy or illegitimacy of euthanasia, even when you can't win the argument, even when you know that other members of society have a different position. And the dominant view in recent history in the UK has been to take on board the principle that John Stuart Mill set out in his essay on liberty, in which he argued that the only reason why it was legitimate to infringe on the liberty of an individual was the need to protect the rights and freedoms of others. So you couldn't do something or restrict the choices that someone was wanting to make on the basis it was good for them. You could only restrict it on the basis that doing what they wanted would have an adverse impact on other people. And you can see that the particular version of the public-private distinction that I spoke about earlier on is a working out of that Millian principle of liberty. But if we want to deny that principle in the modern context, we need to have an explanation of why certain moral values do hold, even if people don't recognise it and even if people don't like it. And so the natural law tradition, which has argued that the application of reason would lead us to the conclusion that certain values held in all times and in all places, and it's just a matter of intellectual reflection. And so anybody who disagrees with that process is wrong, and because they are fundamentally wrong, it's not appropriate to allow them to make those mistakes, would be an alternative way of trying to justify the enforcement of particular moral positions. So those are overlapping. I think they're different, but they overlap considerably, and you may not be of the view that they're quite so distinct. They're all ways of trying to work out what is it that justifies us using the force of law to take a position on end-of-life care that says either euthanasia is acceptable, even though there are strong views and reasoned views in our society that worry that it is an inappropriate step that fails to have due regard to the sanctity of life, or that euthanasia is to be banned, and that has to override the views that it's no one's business other than the patients, and if the patients wish to have that care, who are we to stop them having what they want? We need a justification for using the law to trump those positions which are genuinely held, if we to explain how we move from a debate about the rights and wrongs, in which we have broadly a similar stake, into the recognition of the force of law, in which case we have to bear the sanction of someone's disagreement in the form perhaps of ultimately going to jail, although that's particularly unlikely in most cases.